13th.
Was what? What was she notified of?
At this point, on the 13th, we had discussed removing some of the property and things that needed to be done to the house.
Removing some of the property, personal property, you mean?
Personal property of Michael's that were in the residence.
But you're telling me that you have proof that she was notified that there was issues with the furnace. When was she notified of that?
I can't give you the exact date. I can give you conversations with her acknowledging that there was a problem with the furnace.
The exact date is important.
I can give
the
you
argument that you're making.
The text messages where she acknowledged the issue with the furnace and offered to pay for it.
When did she do that?
It's right here, one of my text messages, man. It's just hard to read right now. So I'm trying to find it.
All right. So the individuals on the car reached out and over the car. Video for you.
Okay, I'm moving on.
If I can take a 5-minute recess, I can retrieve the other device if the information is on.
I got about 10 people waiting in line on this court case right now. I'm going to move on. What else did you want to share? You said something about there being an estate sale.
Yes, ma'am.
And then you said something about there being a point in time where there was others or 20 people that occupied the home. What do you mean by that?
She sent out a mass text, which I have here, to a private group to come and occupy the house.
As in live there?
No, as in remove things from the house.
Or retrieve personal property of the deceased?
Yeah. Yes.
Okay.
And we were occupying the house at the time.
Okay. What was the arrangement when you moved in there? Why did you move in there?
I moved in there to take care of the property. He had just passed. She didn't want the house empty, like she said.
Okay.
It wasn't until after his funeral that we went through with the agreement and I moved into the house. I displaced myself to move into this house. She knew what I was doing because that's how we got to the $400 a month rent, is because she asked me what I was paying where I was living at.
Okay.
So moved into the house with the understanding of securing the property and going forth from there. Going forth from there, we discovered that it was going to have to go into probate, okay, which wasn't an issue. She offered to sell me the house. Okay, so I made the arrangements to purchase the house and everything. Someone offered her more money, is what she told me personally. Yeah, once she found out, it was April 8th when she gained possession of the estate.
Okay.
She then dropped
April
this
8th of last year?
Yes, ma'am. She dropped me the paperwork off to let me know. She told me if I have a problem with anyone, show them this paper that I was allowed to be there at the house.
That paper says you're allowed to be there?
This paper does not. It just shows that she's retrieving or receiving responsibility of the property.
Okay.
So at this point, we started toggling around the ideal of me purchasing the house. There was no, you have to be out when this or this happens. There was no issue until I rebelled against things that she were doing. She had that many people in the house, my stuff came up missing. A lot of my property came up missing. She sold a lot of my property that she knew was mine. And
So
it's at that
you mean at
point,
the estate, there was an estate sale there?
yes, a couple times,
And were you present? Or
No.
were you notified that there was gonna be a estate sale?
yes,
Okay.
yes. And on a couple occasions, I was notified that there would be people coming over. I
Okay,
come home from work one day and the house is full of people and my property's missing.
but you were notified in advance that there would be an estate sale?
Not at that time. There had been more than one sale. She had more than one
Ma'am,
date.
you're gonna get an opportunity to testify, but it's not now, okay?
She set up different dates for people to come and purchase things,
Okay,
his things. I didn't change the locks until I come home from work and there was 20 people inside my house, 20 people going through my belongings, her belongings, and his belongings as well. A lot of our property come up missing. I confronted her about this and she proceeds to tell me that it doesn't matter, it's all about the money, which then I went to the police station, discussed to them what was going on. When I received the mass text of over 17 people that she just sent out telling them to meet her at the house on a specific date.
okay.
They told me I was in my right to change the locks to protect my property, so I did so.
So you move into this house so that it wouldn't be vacant after this person passes away, and your stuff is intermingled with their stuff?
Yes,
their
ma'am.
things? Okay,
I had put all my stuff in the storage before I moved in.
Yeah,
She says,
I
"Why
get it,
do-"
but when you moved in, you had some stuff, some personal items there.
Right.
Okay, and so there's some estate sales, multiple estate sales. Were you notified in advance every time or just sometimes?
Some of the times.
Okay, so there were some times when you were notified in advance. Is that where your allegations are?
Yes, ma'am.
And at the times you were not notified in advance, is that the allegation is that that's when your things came up
Yes,
missing?
ma'am.
Okay, what else you want to share?
I have the text messages acknowledging that as far as these sales. I have voice messages and video of her, continuously harassing me.
What's
her
harassment mean?
Looking through my vehicles, removing mail from the mailbox.
You have videos of her removing mail from the mailbox?
I have a neighbor who witnessed her, and I've witnessed her on my own.
You have videos?
Not videos of
Okay,
it.
is the neighbor here?
No, ma'am.
Okay.
They've moved.
Okay.
They've moved from the
You
house.
personally witnessed her?
Yes, ma'am.
Oh.
She would come over and grab mail all the time, whether I was there or not.
Okay, but then, and this is the mail all the mail that's
That
coming
came
in,
to
some
that
of it could be
residence.
coming for the deceased, correct?
Yes, there
And she's
was.
personal representative, correct?
Yes,
Okay, so she's
Some
grabbing,
of
she's
it,
coming to grab
yes.
the mail, but
yes,
yours is intermingled in there.
yes, ma'am.
And you have seen her take mail?
Yes, ma'am, because
And-
we've exchanged. Oh, here, I've got this of yours, this,
Okay, what makes you think she's kept your personal mail?
well, first, my bills weren't coming, so I called and inquired about my bills. They told me they sent them out to the mail. I go to the mailbox that week, 2 or 3 times that week, and my mailbox is empty, but no bills. So, and I would get a phone call from her telling me, hey, I stopped over and picked up the mail today, or I'm having someone give someone else the mail. I'd get phone calls from her. So it wasn't irregular for me to know that she was going into the mailbox, but in that sense, thinking that she's only taking what she should be taking,
Got it.
not all the mail.
Okay, what else you have?
Like they say they sent me paperwork for the first court hearing. I never received that in my mailbox. Who's to say she didn't, retrieve that from my mailbox? I had no knowledge of that things until the last appearance notice that I received. That was all I had received.
Okay,
I then received a letter from, after it was addressed, I received a couple letters from her attorney. One stating that there was to be no contact. I get up and then she's out there in the yard. The other day I heard my mailbox close. I go outside, she's outside.
when was this?
Sylvia.
When was this?
The
Recently?
yes, last week, recently.
Before 8 o'clock.
Yeah, before 8 o'clock in the morning. She's out with her video camera inside my vehicles, behind my vehicles. I don't, I've had incidences where I have a surveillance camera in the front window. She's gone as far as to put up tape a piece of paper up in front of the surveillance camera so I couldn't see her activities in the yard. And it's at those points when she'd bring people over to pillage. She didn't want me to see what was going on.
What people?
17 different individuals that she was messaging, telling them.
Is that what that is?
Yes, ma'am.
I see.
As the recipients of the.
Or you can take down the phone number.
Okay, this says 17 people, not over 20.
Well, trust me, they didn't come along, each individual person.
Gotcha. And this was from July 2022?
22, yes, ma'am.
Okay, and then July 25, 2022 as well?
Yes, ma'am.
Okay, but this individual had been deceased for how long at this point? Over a year?
Yes, ma'am.
What else you have, sir?
I have more text messages pertaining to her coordinating times when would not be at the house, as well as payments. When there's recorded payments arrangements, like I'll meet you here and give you the money, you can meet me here. I have messaging between her and I for that as well.
Okay.
The bill that she still hasn't refunded me for the furnace work that I had done. And there's still no furnace working.
Okay, but you were living there to take care of the property, though.
Not financially take care of property. I was there to watch over the things that were there of his, to secure his property. I wasn't there to maintenance the house. I wasn't
Okay.
there to, yeah.
And you all discussed who was gonna maintenance the house before you moved in there?
Yes, ma'am. There was no maintenance to be done. I was just there to secure the property.
No, what was the discussion about how maintenance and utilities were gonna be taken care of while you lived there?
I took it upon myself to take care of the utilities, meaning I took them out of, because her and I had a conversation, I took them out of the name they were in, put them in my name.
Okay.
Board and Water and Light.
Did you remember what my question was?
Can you rephrase your question?
What was the conversation that you had before you moved in about who was gonna be responsible for maintenance?
It wasn't until after I moved in, we sat in the living room.
So there was no conversation prior to about who was gonna be responsible for
Correct,
maintenance?
correct.
Okay.
I was already in the house before we had the conversation.
Okay, and when you moved in and you finally had the conversation about maintenance, what was said?
That her concern was finance. So when there was an issue arose or something, she said, she would try and find someone to take care of the issue.
Okay,
Or she would refer a person to me to schedule a timing for them to come in and take care of an issue. There was always an open communication between Sylvia and I.
okay, okay. Anything else you want to share?
No,
Did you have any questions for this witness, Mr. McCarthy?
No, Your Honor.
Okay. Ms. Balzer, you wanted to testify as well, correct? Yeah. Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury? Thank you. Okay, what did you want to add, ma'am?
Okay, so the arrangement again, Michael Scott was, and James were very close friends. When he passed away in an accident, we were all at the hospital. Michael had a lot of property that was worth a lot of money as far as motorcycles, ATVs, stuff like that. In the community that they all belong in with biking, Michael would do a lot of, he worked on bikes. So his garage, a lot of people would come there. There was a lot of property of other people there. So when the passing.
At the.
At Michael, at the
meeting?
estate.
Mhm.
So when he passed, she was getting bombarded with multiple people because they did have bike parts or the tools and stuff at the house. She didn't really know who most of them were. James did. So at first it was, it was just overwhelming. It was overwhelming for everybody, but I'm sure for her, on top of dealing with the other stuff she had to deal with, she has people asking about property. So at first it started because people didn't know the house was empty and that property was at that house that we were at to stay to make sure it was safe. His belongings were in the house. I've helped her pack some. She's asked me to pack some myself. They were put in a corner of the basement away from ours. As far as again, everything was fine. Then the arrangement was made. And I'm just trying to remember everything. As far as the furnace, as soon as it got cold and we tried to use it and realized it wasn't working, her ex-boyfriend, Don Hazen, came over. He looked at it. Her brother-in-law, Moreno, came over, and a couple of people we know came over, and we had an actual gentleman from Mr. Mike George. He does heaters. He came over. They've all concluded that the furnace just had to be replaced. There was no fixing it. They basically took it apart piece by piece. With that being said, we dealt with it. We used space heaters. We made it work. She had brought us, when she was awarded being in charge of the estate, she had brought us the papers because there was issues with, Michael was also recently divorced before the accident. So there was some issues with the ex-wife. That's why she had stated about the papers, just in case she called the police saying we couldn't be there, the ex-wife. We had the divorce papers and she brought us this stating so that they could contact her. She could let them know we were supposed to be there.
Okay.
There was an arrangement made that we were going to try to buy the house so that we could, try to keep it together. She agreed to sell it to us for $80,000. I do have, in the text that James gave you, there's a part where she even asked about the financial institution that we had got finally approved for the mortgage, which was right around the time that the people were coming for the estate sales. And then I do have a text here. But it says, this is 48-hour notice that people will be coming into the house starting Tuesday, July 25th from 8 a.m. to 8 p.m. until the house is sold.
That was in 2022.
Yes. The reason the locks were changed is because, yes, we were told the dates would change a lot when she was coming, which in multiple texts, which was never a big deal. But then when you have multiple people coming to where your personal property is, it is kind of violating when you didn't realize they were walking through where we sleep. Where
You got 48-hour notice.
That was after. This
was
was letting us know that she's gonna have them people come in every day to get whatever out.
That was after what?
That was after the initial sale, when the people were
When
in
was
our
the initial
room.
sale?
It was,
June.
I want to say it was that.
That was the second time. It was in June of 2022.
And you're saying that you weren't notified that that was gonna happen.
I was notified, but the date kept changing. In fact, that the day before, there was people that had to, because it was on a weekend, there was people that had to work, and I believe it was something about, it was a holiday weekend was involved at one point, but I'm sorry.
Okay, I'm just really trying to
People
get to,
cannot
I'm
make
trying
them-
to get to the point where you believe that you have lawful grounds to hold over this property because of what you're
I
saying.
don't,
I'm not
No, my-
disputing, but it sounds like it's that maybe some of your personal items may have been unlawfully sold, or that's what it sounds like, that that's just a small claims matter. I don't know, I'm not getting why you think you should be able to stay in this property.
It's not about staying in the property. It's about having time to move out to another place. I displaced myself once for you, and then you turn around after I confront you about something, say, okay, well, I don't want to sell you the house no more. Someone offered me more money, it's time to go.
How much time were you looking for?
Enough time to find
What is enough
adequate.
time?
I've been searching. I haven't since our last hearing. I've been searching for rental property.
Our last hearing was in December,
Yes, ma'am.
so 60 days to be exact.
Yes, ma'am.
So you don't have.
Application fees, rental properties that they're showing you and for the price they're asking you, I'm not just gonna go move into a closet.
But I
Yes.
asked you, and not that means you're gonna get it, but if you were in a position to negotiate with the plaintiff.
It just gives me more time
What
to
time,
find
you
adequate.
need to have a time. You can't just say more time and then that's an open-ended amount of time. I need 30 days. I need 60 days.
Your Honor, I wasn't given a time limit.
No,
when
I
moved
just
in.
asked you a question. How much time do you think is reasonable for you to relocate?
60 or less.
Okay, and have you tried to negotiate that prior to the
I was
today's court
given a
date?
no contact, do not contact.
Who gave you a
so-
no contact?
Her lawyer,
Mr. McCarthy.
Mr. McCarthy.
Mr. McCarthy, there was a no contact order?
I asked, there's no order. I asked them not to contact my client because my client was frankly afraid of the defendant at that time. But he could certainly have contacted me. I've sent him letters. and-
Was anyone represented by counsel their counsel needs to be contacted? Did you reach out to their attorney to negotiate a time frame for you to vacate the property to avoid this eviction?
No, I was told no contact, you will receive.
No contact to
Mrs. Mack.
Mrs. Mack, but did you contact Mr. McCarthy and say, you know what, I just need 60 days to get out of here?
No, ma'am.
Why not?
I didn't think I was supposed to contact him. He was handling her procedure.
No,
I received
you're
a letter.
representing yourself, so
I
you have,
understand
right,
that.
so if you had an attorney, your attorney would contact their attorney, but you're representing yourself, so you would.
I'm
need to
not an
contact-
attorney. I asked
know
for
you're
one
not.
to handle these situations for me
We don't-
because I
we
didn't
don't
know the
appoint-
proper
We
procedures.
don't
of-
appoint attorneys here. We gave you an opportunity to meet with legal counsel to see if you could be represented by them, but they were not able to take your case. And I recognize you're providing the court with this information here about some code violations. It sounds like the property is unsafe and dangerous. Why would you
It
want to
is.
say, why would you
My
want to,
property is still in the house.
why would
Everything
you
I-
want to hold over this property?
Everything I own is still in the house. So there's one reason. As far as all the violations, I didn't know there were that many violations until the inspection was done.
Who ordered the inspection?
I came down here to try and get the heat fixed for the second time. Last year and this year, I came down because she refused to fix the furnace. After I paid money to have the furnace fixed and it wasn't salvageable, I brought it to her knowledge. I let her know that that's what happened. And she still didn't take care of it. So then this winter came back around, I was in the same situation. So I came back down here. I took the proper channels to get it fixed, to have her do what she was supposed to do. It's at that point that it was discovered that it wasn't even a legal rental property. And
Ma'am?
So I'm not to make excuses, but as far as what you're saying with the moving out, one of the main reason, and it's not an excuse, but the main reasons that things have gotten stalled is we were in a very bad motorcycle accident ourselves in the end of July, and we were pretty much immobile for over a month. James is still his ribs are still broken. and then we lost his mother right before Christmas. So things have gotten a little, and I understand that's life. But that has slowed us down some.
Mr. McCarthy, you have any questions for this witness?
I don't, Your Honor. I would like to put my client back on the stand for very brief.
Okay.
Rebuttal.
Mrs. Mack, you're still under oath.
Okay.
Mrs. Mack,
Proceed.
were there various times when you tried to sell assets that you were part of the estate that you needed to liquidate?
I did. I've got a inventory list. And I have pictures of everything. And several of his friends did want to buy some of his things. And so what I tried to do was arrange for everyone to come on one day. So not to put them out. And I never, ever went over there without contacting them first. From the minute they moved in, I never showed up unannounced.
And,
Never.
and your attempts to sell were attempts to sell the assets of your deceased son.
Right.
Correct. Yes. And
That's all that are still in the house.
that
And
was,
I've got inventory and pictures.
and now to the furnace issue. You were notified by Mr. Martin that there was a furnace problem. Is that correct?
Correct.
And that was in the winter of last winter, so the winter of 21-22.
Correct.
And what did you do because of that?
I tried to get the heating and air conditioning person over there to
Was
go
that-
over and fix it or do whatever, and that they would send me the bill. And then that never happened. I gave them the phone number, who to call.
You gave Mr. Martin the phone number to call?
That is correct.
And was that Hazen Heating and?
Hazel with an L, not Hazen. Hazel.
And you'd contact Hazel already and set up the arrangement that they would bill you?
That's correct.
And what did Mr. Martin tell you when you gave him that phone number?
He said he was going to try and fix it himself. I knew they needed heat. We all knew they needed heat.
But he said he was going to take care of it himself. And after that, did he again call you and tell you that there was still a problem?
No, after that was just, he was just going to deal with it, take care of it.
Okay. And your attempts to sell personal property were attempts to sell assets that you believed were your son's.
I knew they were my sons. All his things are still in that house.
Okay.
Furniture, livable things.
I don't have any other questions of this witness, Your Honor.
Any questions?
Sylvia, did you record all the items that you sold?
Yes, I did. But no one
Oh.
could get their things, so they weren't really sold. Because the locks were changed and
So are you telling me that, is it your statement that you didn't receive any property from that estate? That you did not come and remove anything from inside the house or the exterior of the house?
from
or
the inside of the house. From the inside of the house, I know I got a lot of,
That's a yes or no?
Not
That's a yes or no?
personal. Things.
Let her answer the question.
I got a lot of Scott's personal things. He had like a crazy shoe collection and a lot of clothes and just a lot of his little personal things. I did get most of that I know of out of his
So
bedroom.
is it your statement that you didn't receive or remove any vehicles, any parts, any mechanic parts? Any,
No, from the
any
house. I thought-
furniture?
This question is getting really compound. So you
Well,
gotta,
she's
well, no,
lying.
you don't get to ask compound questions. You get to ask one question. So do you want her to answer yes or no to all three of those? Because what if her answer is yes to one and no to the other two?
I understand.
Got it.
Okay, let me rephrase my question. Did you remove any motor vehicles from the property?
Yes, I took his vehicle, his car.
And that's all?
What is the point to his whether or not his property was removed? How does that affect you?
She's saying that all the property is still remaining in the house when she's
And-
come and removed 90% of his
Who
property.
cares if she came and removed his property? What does that got to do with you?
Because my property was removed.
Well, then ask
as
about your
well.
questions, about your property. I can care less about her removing his property.
My question is to you, you're stating that you did not come and remove anything but items that you knew were his, correct?
Let me help you
That
out.
is
Did you
correct.
remove any personal property out of the inside of the house?
Not his personal property. They knew
Who's
I
his?
was not
Who's his?
Mr. Martin's.
No, did you,
They-
that was not my question.
Oh,
Did
okay.
you have any personal property removed from the inside of the house, ma'am?
Scott's, yes. Scott's personal
No,
property.
no. I asked a very specific question for a reason. Did you have any property removed from the inside of the house? Is it yes or no?
Yes.
Yes,
Okay, and was that under an estate sale or you just had property removed?
I just had property removed.
Okay, and do you know specifically what you had removed?
I do have an inventory list.
Okay, but my question was, do you know specifically what you had removed?
Yeah, a lot of clothing. Oh, everything out of Layla's bedroom, my granddaughter's bedroom.
Who removed it? Did you remove it or you had someone else do it?
I had someone else do it. Yeah, I couldn't do it
Were you-
myself.
Who was the someone else?
Friends, but I was there. Generally, my sister and I would be there. And
How many,
My
how
brother-in-law.
many friends?
pardon me?
How many friends did you have come to remove property?
I know I put out that email, maybe 8 of them showed up.
Okay,
And I
so you had
tried-
about 8 people in the property removing personal items?
Yes, mostly from
Okay,
outside.
so then you don't have a clue really what they took then, correct?
Well, I tried to monitor everyone.
Well, my
Most
question
people
was,
were
you can't
outside.
monitor 8 people at a time though, can you?
If they took some of their things, I didn't know.
Can you monitor 8 people at a time?
No,
Okay, so you weren't able to monitor them each as they were gathering things, were you?
right. I
Okay,
was not in every room.
okay. So is it possible that some of Mr. Martin's personal items may have been taken in the process?
No, they had their own
It's
separate
not possible.
bedroom.
It's not possible?
I want to say no. Their things were separate from my son's.
What do you mean it's separate?
They had their own bedroom and they had taped it off so no one would go in their room. And their
Okay,
other
so
property,
so none of your son's stuff was in the room where their stuff was, correct?
that's correct.
Okay, so when you brought the 8 people, they didn't go into the room where Mr. Martin and Miss Milton stuff was?
That's correct.
Okay,
Ma'am,
any questions? For the witness?
did you tape off things that you believe to be his and mine separately?
What
No, I'm not
specifically are you claiming was taken, sir?
That they were in,
No, what was taken? That do you believe, what specifically?
I don't have the list here, but there was some of her mother's jewelry that she had passed was in our bedroom. Where
She said that no one entered the bedroom.
she
was
clearly
taken out.
went into the bedroom and
How-
marked things for sale in the
In your bedroom?
in every room in the house.
She said that the room was taped off.
No, ma'am.
Okay,
She
then you have
removed the
evidence
tape
of
from
that?
one door, doesn't have a bedroom door.
Okay,
She
well,
removed the
you
tape and
all
placed the
can,
tape.
you all can pursue a civil action against her for that if that's what you're claiming, okay? You haven't did a countersuit anyway, so that's not really germane to whether or not you can lawfully hold over this property. You've not given me anything that gives me the right to let you hold over the property anyways.
I'm not asking to hold over the property, ma'am. I'm just saying my stuff is there. That's why.
I recognize your stuff. Yeah, usually when
You
people
know,
are getting
so-
evicted, their stuff is there. But you requested to have a hearing. You provided this information to both plaintiff's counsel and as well as to the court as to enforcement issues and that this is not a lawfully registered rental. But that sounds like based on the testimony of both you and the plaintiff, that's because it wasn't intended to be a rental property. And That's why it wasn't registered as a
She
rental.
intended to rent it to me and she intended to sell it to me as well.
Well, it
But she
wasn't, it
states
wasn't
in her
intended to
own
be a
words.
rental. It's by the homeowner. This property is in probate still, correct?
Correct.
Okay, so this was not intended to be a rental. You all had some side agreement based on a friendship that you had with her son.
No, nothing was based on the friendship.
That's what
It
you
was
said.
based on securing the property,
That's what you
paying a
said.
monthly rent.
That's
to
what you
stay
said.
there. And I'm still saying.
Yeah, you
that-
said that it was, you were his friend. Now it
Yes.
wasn't based on a friendship?
No, it's not based on the friendship. It wasn't based on the friendship. It was based on morals. It was based on respect. You asked me to come look over the property so it doesn't get violated. That's how you address me. That's how you come to me. The rental was there, the second conversation. Now, after agreeing to looking over the property, we're here, you can rent it for as much as you're paying where you're renting now. That was the second part of our conversation. So it wasn't here, this was your best friend, come stay here and do all that. No, never. There was an establishment from day one. She called me over to her house with her sister, her brother-in-law, and had this big meeting about me renting the property from her.
Okay. All right, we're off the record. I need to handle some other matters. Let's see. Victoria Young. Yeah, you can have a recess for about 5 to 10 minutes. Victoria Young, can you hear me?
Yes, I can.
Oh, very good. I have Victoria Young here. I don't see any other tenants. Did you see anybody? Bring a look. Amy Fountain is present in the court. Mr. Klug, Joseph Mainville appeared early and we set his matter for hearing March 15th at 1:30.
Thank you, Judge. March 15th at 1:30?
March 15th at 1:30. Who's on the Motorola? What's your name, sir? What's your name, sir?
Tyler Manowski.
Okay, 3 o'clock. I need a new date for that, for failure to appear. That's for Bywater. February 22nd at 9:15. Bywater has failed to appear. There was service by attachment. It's gonna be reset February 22nd at 9:15. Tyshawn Duncan failed to appear. There was service by attachment. February 22nd.
Yeah, we can do all of his that at the same time.
9:15?
Yeah.
February 22nd at 9:15 for that one, Mr. Klug. Let's see. Jasmine Willis has failed to appear. There was substituted service. We'll reset that to February 22nd, 9:15. William Farrington failed to appear, substituted service, 9:15. February 22nd at 9:15 is the reset date. Okay, Joiski Willis failed to appear. There was personal service. You can submit default.
Thank you, Judge.
Thank you. Let's see. Anybody here on behalf of Citibank?
Yes,
But yes, Your Honor, Panagiotis Marcellus on behalf of Citibank. Apologize.
Okay, Frank Nelson has failed to appear. There was service by attachment, so we reset it.
February 22nd at 9:45.
February 22nd at 9:45.
Thank you, Your Honor.
No problem, thank you. Brings us up to 3 o'clock. Ms. Albu, I gave the reset date for your matter already. Did you hear it?
Oh, no, Your Honor, I'm sorry. For South Point Mortgage.
Bywater. February 22nd at 9:15 is the reset on that one.
Thank you, Your Honor, and I'm sorry.
No problem. Mr. Joseph, which matter are you here for?
Thank you, Judge. I'm here for the Waverly Park versus Young matter. It's Edward Rose slash Waverly Park.
You have a file number?
Yes. 22-04161 LTE.
Victoria Young, okay, thank you.
What's up, baby?
What's your name, sir?
Ira Page. Excuse me.
Thank you, Mr. Page.
Yeah.
Okay, where's Ms. Fountain going? I'll play this video one time. Okay, Mr. Page, Ms. Fountain, and then Ms. Young, and then Mr. Minovis. I'm going to play a video for you. Today's the date set for a pre-trial on an eviction matter. This video will go over your rights. I'll also advise you of resources that you may be eligible for during the pendency of this eviction. We have representatives here from Legal Services. They can meet with you at the conclusion of the video and see if you're eligible to be represented by their office. We also have information that we can provide you. And then Mr. Minow, I forgot I'm live shooting. Information we can provide you for our eviction diversion facilitator, and you can meet with them to see if there are other resources that can help you avoid eviction, okay?
Yes.
Okay, I'm gonna play the video now. Pay attention and write down any numbers you may need.
Yes.
This video contains important information that may help you with your landlord-tenant case. The 54A District Court has an eviction diversion facilitator on site to provide non-legal assistance, such as connecting you to possible resources. Please contact Ulysses Rosa at 517-483-7608. You have a right to be represented by an attorney. If you do not have an attorney and you are able to afford an attorney, you might locate an attorney through the State Bar of Michigan by calling 1-800-968-0738. If you cannot afford an attorney, you may seek free representation from Legal Services. You should have received this information with your summons and complaint. We have a representative present from Legal Services who is available to speak with you at the conclusion of today's hearing. You have a right to a trial by judge or jury. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Assistance is also available from the Michigan Department of Health and Human Services. If you have a caseworker at MDHHS, then you should contact the Eviction Diversion Program line at 517-887-9595. If you do not have a caseworker, the court will provide you with information for a housing specialist or assistance payment worker at the local MDHHS office. Please contact that person immediately. These services are free. You do not need a judgment to receive assistance from MDHHS or Holy Cross Services. The summons and complaint from the court case are sufficient. If you have served in our armed forces, assistance may also be available from the Michigan Veterans Trust Fund. Contact 1-800-642-4838 and select option 6. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. In such case, a conditional dismissal is possible when approved by all parties. The court can provide you with a form for a conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program. If the court determines that your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Thank you. Your case will be called shortly.
Okay, Ms. Young, I'm gonna set your matter for hearing. It's gonna be March 15th at 2 p.m., okay?
Okay,
Judge,
Want to meet with legal services today?
yes.
Okay. Mr. Matthews, can I put her in the room with you?
Yes, Your Honor.
Judge, before we do that, this is a health hazard involving a shooting incident with the defendant on the property. I believe the police reports are all filed with the court. There is what we perceive as a serious risk factor here. So if the court is not going to in a hearing today, which I understand, can we get a sooner date than a month from today? I think it's in the best interest of the community.
This wasn't filed as a health hazard eviction. Nothing in this filing indicates. Okay, I do see there was a violation for shots fired. It wasn't set as that, but today was a pre-trial date, so we would not be able to hear it today. We can see if we can. Do we have any available?
Just let her know. I actually have the police report, and I went.
Ma'am, February 28th at 2:30.
Thank you, Judge.
Okay, Ms. Young, I have to stop you because I don't want you to say anything that they can use against you, but what I'm going to do is put you in a private meeting room with someone from legal services so they can do their intake, okay?
Okay, thank you.
Thank you.
No problem, but your hearing is going to be February 28th at 2:30.
Okay.
Thank you, Judge. I appreciate the accommodation. Have a good day.
Same to you. Can you put them in a private meeting room, please? Ms. Fountain? We're gonna set your matter for hearing, March 15th at 2:30, okay?
I'm ready to resolve it today.
I'm sorry?
I'm ready to resolve it.
You're ready to resolve it today?
Yes, ma'am.
What does that mean? You're gonna pay in full?
I have the promises to pay. I have one check to drop off, but let's see.
If you pay it in full, they can move to dismiss. But you'd have to do that.
Yeah, DHS is paying $410. City of Lansing is paying $1325. I also have a check from my daughter, Delisa, for $1135.
Do you get her on Zoom? Do you want to meet with legal services or do you want to just talk to Mr. Klug today?
I would like to talk to Mr. Cool.
Okay, can you get her on Zoom, please?
Your phone,
Yeah.
is that Zoom?
Mr. Page,
Yes.
your matter is set for hearing, March 15th at 2 p.m. Did you want to talk to legal services today?
Yes.
Okay, we'll get you on Zoom. Do you have a phone with you?
Yes.
Okay. Mr. Middlebeth. Your matter is being set for hearing, March 15th at 2 p.m., okay? You're muted. Tyler, you're muted.
That's sorry. That's what I was trying to ask. I haven't used Zoom in a long time.
No problem. Did you get your hearing date?
Can you say that one more time? My service is the greatest.
Yep, March 15th, 2 p.m. in the afternoon, okay?
March 15th at 2 p.m. in the afternoon. Okay.
Okay. Did you want to meet with legal services?
Yes, if I could, please.
Okay, we'll get you in the private meeting room with someone.
Right now
I'll
you're
leave
saying?
you until they're, I'll get you in a private meeting room with someone as soon as someone's available. Let me put you on mute, okay?
All right, perfect. Thank you.
Your Honor, Mr. Rose is available, or Jalen Rose is available to do intakes this morning.
Okay, sounds good. I'm gonna put Mr. Page in there once he gets logged in because he was here first. Lynette Farr. I don't know what matter she's here for. Who is Lynette Farr? And is that Mr. Wimberly? Okay, you're muted, but I think you said yes. Is Lynette Farr someone's client? Because if they don't identify themselves, I'll remove them from the virtual courtroom.
I think Lynette is our office manager now.
Maybe.
Okay, well, I'm contacting her. She's not responding.
Okay. Yeah, that is Lynette from the office.
Okay.
But David Cox is representing the Capitol Council.
There's a lot going on. Sean Moore. Is that one dismissed? Correct. Sean Moore, the last one. Okay, Michonne Moore.
Yes.
Okay, your matter was dismissed.
Okay.
Thank you.
Thank you.
Oh my God.
Ms. Compton wants to meet with Mr. Klug. She needs to start her audio. Mr. Klug, I'm going to put you in a room with Ms. Fountain.
Thank you.
Jalen Rose. From Legal Services, we're supposed to go in the room with whom? Oh, Mr. Page, he hasn't logged in yet. Okay. Ms. Wilburn?
Good afternoon.
Good afternoon. I have Mr. and Mrs. Wimberly here. Mr. Wimberly appeared earlier and we conducted his pretrial. The matter is set for hearing March 15th at 1:30. He is still here, however, because he believes that this was something that was supposed to be worked out within the 90-day time period. And so he wanted to have an opportunity to speak privately with you to get that resolved if possible.
Okay, and you said that was adjourned to March 15th at 1:30.
No, it was not adjourned. We set it for hearing. Today was just a pretrial.
Okay,
So the hearing will be March 15th, but he wanted to speak with someone today because he said he spoke with the management office, which I believe is who Lynette Farr is here for. And that he was of the understanding that there was supposed to be a 90-day period for him to work this out due to some issue with his lease.
okay.
So what I'm gonna do is put you and the Wimberleys and your client in a private meeting room so you all can talk about that, okay?
Okay, thank you.
No problem. Your client is Lynette Farr, I believe. Farr, room 3. Amy Fountain. Where's Bigelow? He needs to help her. He might be with Paige.
Join.
Click join, yep.
This is a circus. Where's the I'm going ready to go back on the record for this hearing. They're not here. Ms. Till, can I put Mr. Minovisk in the room with you?
Sure.
I'll move him to room 5. Okay, we are back on the record in the matter of Sylvia Mack, personal representative for the estate of Michael Scott versus James Martin and Sunshine Balzer. We took a brief recess so the court could get through some other proceedings that were scheduled. Did you have any other evidence that you wanted to submit at this time?
I did submit the receipt from the maintenance of the furnace as well, didn't I?
I didn't see it. Can you get that, Mr. Bigelow? Okay, it's a receipt for $415 from December 2021, correct?
Yes, ma'am.
Okay. Mr. McCarthy, you can make your argument.
My closing argument is that my client needs to have possession of the property in order to cure the issues of that the city of Lansing has found with the property, that this was not meant to be a formal rental relationship in the first place. And I believe that both of the defendants and my client testified that this was really a friendship that existed between the deceased and Mr. Martin, that was the impetus for the creation of this relationship. Your Honor, what I'd ask in terms of a judgment is a possession judgment, and on damages, I have a total of $2,771.38, and that is computing the rent through today's date, not through any extension period for the rest of the month of February. That includes costs of $171.38. And I don't have any problem if the court reduces that amount by $415 based on the furnace repair that was just submitted. And so I'm asking for 2,771.38 less $415 as a money judgment in this matter, Your Honor.
Thank you. You can make your argument.
The plaintiff refused payment from date after July. I think that's why in her initial statement that they were only pursuing $800 for the 2 months rent that she claimed that I owed for her 2 months rent. The 200 or 2,000, whatever that is absurd because it wasn't from lack thereof trying to shoot. They refused. They put every wall up to prevent contact and communication. That was not done on our part. She ceased the relationship.
Any other argument, ma'am? Okay, having heard the testimony and reviewing the evidence that was presented, the court is of the opinion that there is no lawful reason or basis whereby to grant holdover possession to the tenants or the defendants in this matter. I don't believe that there was a formalized landlord-tenant relationship in this matter. I think both of you all testified to there being some arrangement based on a relationship with the deceased in this matter. Understanding when you moved into the property that this is a situation where there was someone who's deceased and that the property would need to be liquidated in some form and that you were there just to help secure that person's thing so that they wouldn't be subject to being stolen and that Mrs. Mack wouldn't be subject to being bombarded. You were there more or less as a safety or a safeguard. And so you put yourself on the line on that. Whether or not you lost some personal items in the process, I'm not sure. It sounds possible that you did. But that's something that you're gonna have to pursue separately. I don't have a counterclaim here that I'm ruling on. But that's up to you if you want to file a small claims or a counterclaim for recovery of any of the lost things. But as it relates to a landlord tenant, there's no lease agreement. There was a verbal agreement about an arrangement for you to stay there. Whether or not you feel like you had a negotiation about owning or purchasing the property, that's really not before the court to rule on. They do have the right to recover this property and they need to recover it so they can proceed with the probate issue, which should be an understanding or should have been an understanding when you moved into there. It's not clear to the court who was responsible, well, it wasn't clear, I should say, who was responsible for maintenance of the home as it relates to the furnace and such, but we did have on a retestimony from Mrs. Mack a statement that she was referring something that you were supposed to submit the bill. Well, we have the bill here, so we'll make sure you get paid for that. We'll deduct the amount of $415 from the total recovery and damages. What we have here on your notice to quit, and for the sake of the time that you received, this notice to quit is dated from August 2022, and at the time it states here. Give me just a moment, sir. I'm going to absolutely give you an opportunity to ask your question. At the time here, because you mentioned that there was only a request for the $800, it says that you, at the time, which is this is dated for September 1st, that it said that you at the time was indebted for $800 in rent from July to August. Well, now we're in February 2023, and they have the right to tack on each month that you're holding over this property without paying any money. You could have put the money in escrow, you could have put the money aside, whatever the case may be, but you did not vacate the property. It wasn't as if you left after you got this and then you said, no, the property was, don't talk over me. The property was vacant. And so that's why I am not liable for these amounts. You're still in the property, correct?
Yes.
Okay, so then if you're still holding over the property during that time, they are entitled to seek recovery for that amount. You wanted to ask me something?
Yeah, she said fines for damages and such. If you can be more specific on what those are. Because
Damages just means the amount that they're seeking. This doesn't mean that you made damage to the property.
Okay.
It's a legal term for the amount of they're trying to recover.
Okay, and like I said, it wasn't, and I have her text message terminating the relationship. That wasn't done on our part.
And that's fine.
So,
You don't have to, it doesn't have
therefore-
to be done on your part.
Therefore, I couldn't pay for it like, I didn't know we were being evicted until we got the letter in the mail. That was well after September. Because like I said, to her, to him, we received nothing stating, hey, I want you to leave, you're being evicted.
Okay, there was a substituted service on this, so someone received something.
No one received anything out of her mailbox.
I
Until-
recognize there may not
until-
have been anything in the mailbox. We have noticed here that there was personal service.
No, ma'am, no, ma'am.
And that was.
So there would be a signature if there was personal service, correct?
This is what we have in the proof of service from the service processor. Says they were served personally, and they attached their oath on it. The Mindy Miller process server said that she served you personally with the notice. What are you referencing that you were served with?
We didn't.
Or you mean the notice to quit? Or are you talking about the summons and complaint?
We didn't receive anything outside of saying you have a court date on the 13th.
Oh, okay, so you're talking about the notice to quit. You're saying
Yes.
you never received the notice to quit.
Correct. And I tried to establish that during the first hearing, but I was kind of shushed and pushed off. But the due process was never put into place. If we would have known we were being evicted, we would have started looking for a place to live at that point. If we were known we were being put out the house, we'd have tried to make further arrangements for residency.
Okay, we also have here a proof of service attached from the notice to quit indicating that the owner served you on August 1st, 2022. So I don't know what happened to your mail or what could have happened. Ms. Mack is saying she didn't touch your mail as it relates to this. She was questioned about that under oath.
She's lied about a lot of things on the oath tonight.
I recognize that, but what I have here is, I don't have a burden. You haven't met a burden for me to establish that you should hold over this property based on what you're saying happened here. I believe you had a sufficient notice that there was a reason for you to have to move out of the property.
December of this month, you just stated it yourself.
Well, December this month is when you were served with the notice to quit. And actually, December was when your first court date was. So you had notice before December because we have another proof of service. There's more than one proof of service here. You have a second proof of service indicating that you were served with a summons and complaint. That was in September of 2022.
Only notice that, like I told you during the first hearing, it was to show up for that court.
That was in September.
That's our first court date.
Now, you received that notice in September and you were not even going to come to court until December. That is what the court date was. Yeah. That's what the notice to quit, but because we were so far behind, we had to set stuff out that far. But your notice to quit, your summons and complaint is you were served personally is what the proof of service says. And that you didn't have to come to court until the first appearance was being in December. Nonetheless, I don't have anything that gives me the right to give you ownership or possession of the property. What is the total amount in recovery, Mr. McCarthy?
$2,356.38, Your Honor.
How is that?
And what does that entail?
That is the monthly rent from July 1st till today's date, and $171.38 in costs, less $415, which is the amount of the receipt that's apparently in front of you.
She was charging rent, so she was renting. I mean, give or take, either she knew it was a rental property or she knew it wasn't. Now she's trying to charge me for damages for rental.
You already agreed that you had to pay $400, that you had an agreement $400. You told me that yourself. What I said is that I didn't believe that there was established and a formalized landlord-tenant arrangement. That's based on your testimony as well. You didn't move in here to rent this property. You moved in to secure is what you told me.
Yes. And then the $400
So
a month were going towards the tax.
This was never,
property.
so again, it was never intended to be a rental, which is why, that would explain why the owner who passed away never had it registered. She didn't have it registered because you were moving in to secure the property so it wouldn't be vacant while she tries to liquidate her son's things.
So how is she charging me damages for rental?
Because you had an agreement that you would make payment of $400 per month. That's based on your own statement, sir.
Okay.
she's not received that since July, is what the summons and complaint says. And you haven't provided at least the court any evidence that shows that you have paid that. Okay, so judgment will be in favor of the plaintiff in this matter, minus the $415 for the furnace. Can I get a judgment form prepared by you, Mr. McCarthy?
I will, Your Honor. I have I'll try to get it to you this afternoon, but and I believe I can do that. Okay?
Okay, sounds good.
Thank you, Your Honor.
This paperwork back. Any additional matters for the record?
That's it from the plaintiff's side.
Any additional matters from you all?
Yes, I plan on, can I have I'm trying to think of the word. Appeal for the damages and
appeal of the damages.
yes.
There's no appeal paperwork here, but you can go down to the clerk's office if you want to file paperwork as it relates to a counterclaim or a claim, not a counterclaim because this one's been resolved, a claim against Mrs. Mack, but there's no appellate paperwork that you'll get from us on this matter, okay? You're all set.
Thank you, Your Honor.
Thank you.
I just wondered when I get the property back.
Ma'am, I'll talk to you. I'll give you a call, okay?
Okay.
What's the writ date?
Thank you.
Okay. Thank you.
February? The writ date is February 26th.
Thank you, Your Honor.
7th.
Yes.
So that's
the date that they can request to have a writ to execute to get the property vacated. They can request that by law within 10 days.
so within 10 days, we have to be out of the house.
That is the law.
And she gets full month rent as well.
Full month of, that's,
For
the rent was due on the 1st.
no, our rent was never paid on the 1st. Our rent was paid at the
Your
end of
Honor.
every month, the 29th of every month.
Mr. McCarthy?
All I calculated the damage amount for was rent through today's date. I didn't include any portion that extends beyond today. So the 2356.38 includes rent from July 1st to February 15 and $171.38 in costs, less the $415. So I'm not asking for any rent beyond today's
They
date.
didn't ask for 415 for February.
Thank you, Your Honor.
Thank you. I don't see anybody here for long.
Yeah, he signed off.
You're free to go, Mrs. Mack.
Thank you.
Ms. Wilburn?
Yes, Your Honor.
No one's appeared on behalf of Barbara Lott. We're gonna reset this matter because there was service by attachment.
Okay.
February 22nd at 10:45. February 22nd at 2:45 is the reset date.
Okay, and we can appear by Zoom for
10:45?
that, correct?
I'm sorry, it's 10:45.
10:45, okay. And we can appear by Zoom for that, correct?
That is correct.
Okay.
Let's see, Mrs. Barr is all set. Okay. Amy Fountain, is she all set? Mr. Kluger, you all set with Ms. Fountain?
I just told her that we're still gonna keep that March 15th date, but hopefully we'll get a conditional dismissal prior to then, not appeal.
All right, sounds good. Thank you. Did you need anything else from us, Ms. Fountain? You're all set.
Just keep that quick date.
Yep, you're all set for now, and it sounds like you may enter a conditional dismissal before then, okay?
All right, thank you.
Thank you.
Thank you, Judge.
Thank you.